of the felony of assault by strangulation, sexual penetration through force or coercion, and the victim sustained personal injury.
In one incident, described the strangulation by being lifted off of the ground by the neck with both hands.
Welcome to Bench Report Court Cam.
Court does call the case of the people versus Gerald Childs. Yeah, I'm sorry.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
And good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs. And then say your name, please.
Your name, sir?
Gerald Childs.
Thank you.
Today is a time and date set for the probable cause conference, and it is my understanding that it's going to be a waiver. I've been in touch with Mr. Bernstein, and we've been talking about a resolution that will include count 1, sexual conduct in the first degree, count 2, the GBH, count 3, the FTD, and count 4, the larceny from a person. We do not have an agreement at this time. So the waiver will be on those 4 counts with an added count 5 of criminal sexual conduct in the first degree and an added count 6 of criminal sexual conduct in the first degree.
So count 5 and 6 of CSC 1.
Correct. And the PAT code for the added counts is 750.520B. It's a multiple variable. It'll read exactly as count 1 that the defendant did engage in sexual penetration with Audrey Sheeran under the following circumstances during the commission of the felony of assault by strangulation and or defendant aided and abetted one another and effective sexual penetration through force or coercion and or defendant effective sexual penetration through force or coercion and the victim sustained personal injury. With the same penalty, life offense.
So he's going to be bound over on 6 counts.
Yes, Your Honor.
Is that correct? And all right, very good.
And if the case does proceed to trial, it would be on all 6 counts. We will not remand for a preliminary exam, but the plea negotiations will involve counts 1 through 4. If we don't reach a plea and go to trial, it will be on 1, 2, 3, 4, 5, and 6.
That's your understanding, Mr. Birch?
Yes, Your Honor. We have the raw workings of a deal. It'll eventually be a plea involving just like 1 count. The 2 additional counts will be dismissed later. If we go to trial, they will be present, though. So we understand that.
All right. So you're waiving your right to preliminary examination?
Yes, sir.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
Okay. And you understand you will not have that hearing and that you're proceeding to circuit court for further resolution?
Yes, sir.
All right. People also waive the right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, and the added counts 5 and 6.
Your Honor,
I'm sorry, for the waiver, Your Honor, could you just indicate what the penalties are on counts 1, 5, and 6 for the defendant?
On counts what? On counts 5 and 6?
1, 5, and 6.
Yeah, I did indicate, I think it was indicated that the 5 and 6 certainly were indicated. You understand that those are life offenses, sir?
yes.
All right.
Thank you.
We understand and waive any further reading, Your Honor. Mr. Childs stands mute, and I'm sure Ms. Reiser will send me an amended information.
Pending and waiting for more reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pretrial will be set for?
January 21st at 1:30.
Said 21st.
Yes.
January 21st, 2025, 1:30, Judge Conkey. Bond, as denied, will continue.
Thank you, Your Honor.
Clerk calls the case, People versus Brady Peterson.
Morning, Your Honor. James Fifelski, standing in for counsel of record on behalf of Mr. Peterson. State your name, please, sir.
Brady Peterson. You have any objection to Mr. Fifelski standing in?
No.
All right, thank you.
Your Honor, we would like to keep this on for a preliminary exam at the next
Is
available
all
date.
discovery complete?
I believe it is, Your Honor. Also like to argue bond if I could.
Would the people have their witnesses available the 21st?
Perfect.
Preliminary examination in person will be set January 21st, 2025, 9 a.m. before me. As to bond.
Your Honor, as to bond, it's my understanding bond is currently set at $150,000 cash, maybe surety. It seems pretty high given the fact that these are 10-year felonies. My understanding is that Mr. Peterson does not have any adult felony convictions. He has been gainfully employed at Blue Star Demolition in Macomb County, where essentially has been raised in Macomb County. So minimal contacts in Washtenaw County. Understand he has not had any contact with the complaining witness since October 15th and has had no reason to. They broke up. They haven't had any communications. So he really has no reason to be in this county but for the court proceedings, and otherwise has a resident with his aunt, I believe.
Yes.
In Clinton Township that he'd be able to either be tethered to or home confinement with work. Some way, Your Honor, that can, I believe, assure the court that though he won't have any contact with the complaining witness and he will continue to appear for court proceedings. And lastly, he also has 2 children. One is a stepson that he has joint custody over and cares for him back at home in Clinton Township. He also has a 6-year-old son who passed away last year unexpectedly from a rare heart disease. So I think he is a good-hearted family man that will take these court proceedings seriously. Just ask for a significant bond reduction so that he can post something reasonable.
Response.
So we requested 250,000 cash or surety. I understand that it was set at 150,000 cash or surety in this matter, but that's still lower than what we asked for. There were 2 counts of strangulation because, to our knowledge, there were 2 counts of strangulation that occurred over a time span. The defendant also has 3 holds, one out of Buena Vista Township for $15,000, a hold out of Davidson Township for $100, and a hold out of Clinton Township for $10,000, 10%. He has a lengthy criminal history dating back to 2010 with a juvenile adjudication for armed robbery. He also has 2 convictions for DV second and R&O, and interfering with a crime report, maluse, obstruction by disguise, as well as numerous dismissed DVs. In this particular case, the police were contacted for a welfare check by the victim's mom, because despite the fact that the victim and the defendant were broken up, the defendant had been sending out sexually explicit material of the victim to other parties, including the victim's mother. When law enforcement contacted the victim, it was only then that she disclosed these acts of violence that occurred over the span of 2 months. These particular incidents are 10-year felonies, but they are rather severe strangulations. The victim in one incident described the strangulation by being lifted off of the ground by the neck with both hands. She ended up on her back on the floor where she continued to be strangled to the point of almost losing consciousness, describing it as if she was seeing stars. She had photos documenting this with large bruising on both sides of her neck, consistent with fingers ripping. The fact that there was continued conduct after the breakup makes me concerned that the fact that they're separated is not the conclusion of this and is not the end of the threat that to the victim. I don't think that any reduction below 150,000 at this time is appropriate.
I would just respond by stating something like a tether or even home confinement in Macomb County, which is at least an hour away from Washtenaw County, would be significant to protect not only the complaining witness, but the community. And I don't think otherwise, with strong community ties in Macomb County, my client is a flight risk to fail to his obligations to this court. The details of the case can be dealt with at preliminary exam, and I can't speak to that. other than the fact that I think 150,000 is excessive, given the fact that these are not capital or more serious felony offenses.
Motion for bond reduction is denied. For police and bond is set as is appropriate. Thank you.
Thank you, Your
Thanks
Honor.
for watching. Stick around longer and click the highlighted videos to your right. See you there.